morning is City of Akron versus Paula Conkle. Apparently, Paula Conkle has waived her argument this morning, so the City of Akron will be the only party speaking today. And Attorney Bremer, as you will, we're going to be 15 minutes. And we have read the briefs and we're ready to proceed.
Thank you, Your Honors. Brian Bremer on behalf of the City of Akron. This case today presents an unusual fact pattern, but it's not a particularly difficult legal issue. The defendant in this case, Paula Conkle, was convicted of obstructing official business when she hindered, delayed, and impeded the police officers when they were attempting to arrest Barry Hartman at the residence the two of them shared. Ms. Conkle, and before I get too deep into the actual argument, there's one issue I do want to point out, which is that in Ms. Conkle's reply brief, she says that the city never actually addressed the primary issue in this case, which was whether or not the officers needed to show her a search warrant before they entered the property. It's interesting that that she's saying this is the primary issue in the case, since it's not actually mentioned in her actual brief. It's only raised for the first time in the reply brief, which is not permitted by the rules or by the established case law of this court.
I thought he argued that they had enough time to go get a search warrant rather than just go into the house. I thought they did argue that in the brief.
Whether or not he said that they had time to get a search warrant, he didn't say he didn't cite any case law for the idea that failure to show a search warrant is what stops you from going into the house, which is what he is saying, and that he says that's the primary issue in the reply, is that the fact that they didn't show a search or an arrest warrant, and that's not ever raised in the actual argument of the brief, meaning that it's not actually properly before this court. Furthermore, his argument in his reply brief is based upon a case from the U.S. Supreme Court involving an administrative inspection of a property in San Francisco back in the 60s, where the individual was convicted for not consenting to a search. And the Supreme Court said, absent exigent circumstances, you need to have a search warrant to enter the home to conduct the search. And on top of there being exigent circumstances here, what also differentiates this case from that one is the fact that there is a felony arrest warrant for someone who's living at the house. And felony arrest warrants allow you to enter homes to arrest the person who's the subject of a felony arrest warrant. And that's in his reply brief. It's not probably before you, but I wanted to address that because I did not have a chance to respond to that in writing. As I said, the issues here are a little bit unusual. They are, Ms. Conkle is not the subject of the arrest warrant. She is someone else who lives at the property. But it's important to remember that she was the person who was there, she was speaking to the police officers. And what happened in this case, the officers received information from the police dispatch, which indicated that Barry Hartman, who had a felony arrest warrant, that he was staying with Ms. Conkle at 246 Kingston Place, that the Wattsburg Police Department had just pinged his cell phone, and that it was located at 246 Kingston Place. And when the officers went to the house, and I apologize, the Wadsworth Police Department also told the Akron Police Department that Mr. Hartman was possibly armed and had threatened suicide by cop in the past. And Officer White in this case specifically says during his testimony that when he hears suicide by cop, what that means to him is that he's going to be put in danger by the individual if he goes to arrest him. There's a high likelihood the individual is going to put him in danger to try to promote that outcome in some way. So he's already on high guard when he approaches these situations involving individuals that have that on their report. Officer White and Officer Gilmet went to the house, and they were greeted at the door by the defendant, Paula Conkle. They asked if Barry was there, and Paula Conkle said, "No, Barry's not here, but if you give me a moment, give me a minute, we can work something out." That's an unusual statement. That is a very unusual. If Mr. Hartman didn't actually live at the house, the response is not, give me a minute, we can work something out, or why are you here looking for Barry? It's, Barry doesn't live here. Like, why are you here? Instead she said, no, he's not here, but then she goes on to say, give me a minute, we can work something out. And the officers point out, well, that indicates he's probably there, because what is there to work out if he's not there?
Well, does that mean that he doesn't live there? Give me a second, I can make a call and tell him to get over here or something like that? There's other possibilities.
There are other possibilities, but she didn't say, give me a minute, let me call him. She just said, if you give me a minute, we can work something out, which is not saying I'm going to see if I can get him to come here. It sounds like you're trying to buy time for someone inside the home. And that's the way the officers interpreted what happened. And this also goes to, I guess, another issue, which it's not entirely clear from the appellant's brief what the challenge is to the actual underlying conviction. The city believes it is a sufficiency of the evidence argument, because he's arguing that it is a matter of law that the conviction was in error. And there's no argument about credibility within this case. So you need to, under those circumstances, the evidence that was presented needs to be viewed in the light most favorable to the prosecution, which is the city. And so the officer, when the individual makes those statements to the officers, that statement should be viewed in the light most favorable to the city as far as establishing whether the person lived there or not.
Counsel, at trial, what was the state's theory on what act or conduct created the obstruction charge?
The prosecution took the position that I believe the entire encounter is what the officers viewed as being the delay, because she told them that he wasn't there, which turned out to be a lie. He was there, and they would have gone into the house immediately if she had told them the truth that he was at the location. She also, when they actually tried to enter the home, she grabbed hold of the door and tried to hold it shut so that the officers couldn't go in. And then she proceeded to fall down and flail in the hallway in a way that tried to impede the officer as he stepped over her. And so any one of those acts basically would have been enough to actually be an overt act to impede, but also at the same time, all of them taken together, it really rose to the level of being obstructing clearly, because...
Didn't she originally ask if they had a warrant during the initial interchange? Did she ask them if they had a warrant?
I believe that she asked them if they had a warrant, and they said, yes, we have an arrest warrant.
Okay, and so explain to me what the theory is in terms of what was the exigent circumstance.
The exigency arose after the officers had approached the house. What happened at that point was, again, the officers had information from Wadsworth Police Department that this individual was possibly armed. The individual they were looking for, not Ms. Conkle, but the individual they were looking for, Mr. Hartman, was possibly armed, and that he had threatened suicide by cops. So the officers were concerned at that point when they approached that they need to be careful. When they spoke with Ms. Conkle made the comment she did about being able to work something out, which again made the officers believe that that she was actually lying to them about whether Mr. Hartman was there, and that it led the officers to believe that she was buying time for Mr. Hartman to do something. Under the circumstance.
I'm sorry, so you're suggesting that her behavior, the things that she did are what raised this to now exigent circumstances where it wasn't before?
It was not exigent as when they approached the house initially, because it's just a casual, it's just an encounter where they're trying to ask a question of the person who's living of the people who live in the house. But this was a slow rise basically to the point of being exigent, and that's what I'm trying to lay out here. It's not just one act, it's not just one thing, it's the totality of circumstances ended up getting there by the end. And what happened then was when they spoke with her and she indicated, he's not here, but we can work something out, the officers became further concerned that he was there, she was lying to them, she was trying to buy time for someone, and given the facts that they knew that he could be armed and that he wanted to commit suicide by cop, they thought that he could be setting up an ambush for them inside. Then the alarm goes off. And at this point, the officers can no longer hear what's going on inside the house. The officers are now outside this home with someone who's trying to attempt to delay them from entering, with a suspect that they believe is in the home based both on her actions and on the fact that his cell phone had been pinged there less than 15 minutes earlier. And now they can no longer hear whether the people inside the home are setting up an ambush for them. And at that point, they decided that they needed to go in to make sure that they were protected themselves, because even if they had walked away from the house, they would have been in danger of being ambushed on the way back to their cruisers. So they chose to go into the home to try to secure Mr. Hartman, and that's when she attempted to blockade the door, both by holding a shot and then falling down and stopping them from getting in the hallway, which at that point was making it even harder for them to be wanting to look out for Mr. Hartman when they came in. Luckily, after they were inside the home, he just came down the steps and was arrested. So it didn't rise to any situation beyond that. But the officers had a lot going on with what was known to them at the moment they approached the house. That then her
So
behavior.
Is that the standard, whether or not they were reasonable in their belief that he was present?
It is the standard. It's the standard for whether or not to go into the home under the felony arrest warrant is whether or not they have a reasonable belief that the person is present.
Does that equate to probable cause?
Is that?
Does that equate to probable cause?
The Ohio courts have said no. The Ohio courts have said it's something less than probable cause. Out of the duty of candor to the court, I point out that federal courts have disagreed on that. Some have said that it does require probable cause. The majority actually do say that it's something less. It's probably closer to reasonable suspicion that the person's inside the home. Having said that, if you view all this evidence in the light most favorable to the prosecution, it does rise to the level to give someone a reasonable belief or probable cause that this person's in the house. And that not only that, but the person lives there. Because they were told by another law enforcement agency that this person stayed at this house with Ms. Conkle, and then the cell phone was pinged to that location. When they approached, Ms. Conkle didn't say this person doesn't live here, and she didn't ask who's Barry. She said, no, Barry's not here.
Well, did they say, does he live there? They just say, is he here?
She
Right?
said they asked, is Barry here? And she said no, but if you give me a minute, we can work something out. Which, and again, that is not something you say if a person doesn't live with you. I don't. If someone came looking for one of my friends and said, is John here? And I'm like, no. Why are you looking for him here? This isn't his house.
So does the case rise and fall on whether or not the, Mr. Hartman is a resident at that house instead of just a visitor?
The case law is if he lives in the house, they can definitely go in to arrest
They
him.
don't know that though, do they? Do they know that?
They know that he stays at the house, yes. And the reality is, there are certain demographics that say stay at a place to mean that they live there, not just visit, not just something beyond, and it's also not just a visit. This is not just a person who, stay does not imply that someone has just gone over to have dinner at someone's house. It implies something more permanent, which would rise to the level of being a residence under the facts presented here. And it's less clear how long, but if you don't, I think it's pretty clear that on the one extreme you have the property's deeded to them, it's in their name, you know that they're domiciled at the location. Like, that's one set of circumstances where it's very clear that's their residence. But then this gets close, this is less clear of a circumstance because it's not clear whose name this home is in. It's never established that it's in Ms. Conkle's name. And it never comes up that she actually lives at this address. Because there's nothing in the record to indicate that she lives at 246 Kingston Place. It's just that Mr. Hartman stays with her at that address. So under the circumstances here, the evidence is equally strong that he lives there as she lives there. And I think and no one's arguing in this case that Ms. Conkle doesn't live at that location. It's pretty clear that she does. And if you look at the evidence in light most favorable to the prosecution, it's pretty clear that Mr. Hartman lives there too. At least to the point of being there long enough to establish some sort of expectation that the officer can go in and arrest him. But even if he doesn't live there, even if it's not his residence, the exigency of the circumstances also provide an alternative reason to be going into the house, which is that the officers need to secure the location for the purposes of protecting their own lives at that point. And they had a reasonable belief to believe that they were in danger in light of the fact that Ms. Conkle was very clearly engaging in behavior that was trying to buy time for someone who was a dangerous suspect that they needed to arrest, and they knew that would have high likelihood of putting them in danger. And either one of these theories would be enough for the officers to go into the house, and we believe both of them apply in this case. And that's what was before the court, and again, the challenge here is really sufficiency. And when you look at everything in the light of favorable to the prosecution, it gets to the point of being enough to get into the house. And Ms. Conkle then, when she tries to stop the officers from getting into the home, on top of the fact that she lied to the officers, on top of the fact that she delayed the officers, and on top of the fact that she did so when she was speaking to the alarm company, indicates that she very clearly was trying to impede the officer and obstructing them in engaging in their official activities. So if there's no further questions, the city respectfully requests that you affirm the decision of the Akron Municipal Court.
Thank you.
Thank you.
For the presentation tonight. The court will take the matter under advisement, issue a written decision which will be held on both sides, as well as posted to our website and at the Supreme Court.
Thank you, Your Honor.
Thank you.